Good afternoon and welcome back. Welcome back to our first webinar for 2021. Can you believe it that we are here again? Before I go any further, may I say, I never know whether it's too late to say this, but I'm going to say it anyway. Happy New Year to you. Let's hope that 2021 is going to be a prosperous and a healthy 2021. But I also think we should take a moment just to celebrate you, because it has been a very difficult year. Many of you have had to manage staff, you've had to manage your businesses, and you've also had to manage your personal lives. And for many businesses, you've also had to contend with Brexit. So I think we'll take a moment now and just do a little nod to you and say, this one's for you. Today's webinar, we are going to be trying something a little bit different. We're going to be splitting it into two. So we're going to be starting off with HR life after Brexit. We will touch on any Brexit questions that you may have before we move on to COVID and employment matters. I think by now we are all quite well versed with COVID and employment matters, but we are always getting questions that are coming in, and I would like to continue to be able to support you during this time. I can see we've still got some people joining us, so I won't get started just yet. But what I will just remind you is, of course, today's webinar is HR life after Brexit and a COVID-19 employment update, just with a couple of things that have come up in questions in the last couple of weeks. Just a quick reminder, it's Friday, the 22nd of January, and I'm going to be hosting this webinar for the next hour. But of course, if anybody who's been on here before will know that I'm not very good at keeping my timekeeping, but hopefully you'll be able to stay on for the duration of the webinar. But of course, if you need to go, it will be recorded and you won't miss out on anything. So for those of you who are joining me for the first time, who are HR for UK? HR for UK is a leading provider of HR and employment support. We provide payroll and pensions, and we also provide health and safety services. We've got over 30 years of experience in the industry, and we've got some fantastic 5-star reviews. And I would really encourage you, if you haven't done so already, to pop onto our website just to read what other people have to say about us without me having to tell you. So our website is www.hrforuk.com. Go and have a read for yourself. Me, of course, for those of you who know who I am, will know that I'm a familiar face. But for those of you who don't, as an employment and as an HR and employment law solicitor, I'm the Managing Director of HR for UK, and I'm responsible for HR for UK's role as a leading professional in HR services for UK businesses. Many of you will have a look at my photo when you register. When we started doing these webinars, I had a bob. When I was busy preparing for today, I looked at myself in the mirror and thought, oh my gosh, my hair's got long. I perhaps need to cut it back into that well-recognized bob. But my vision for your business is to come out of this crisis successfully by offering you clear, professional and practical advice and support. Do you remember there are questions? I've already seen that Vipin, you are the first person in 2021 to pop your question in the question box. For those of you who are new, there is a panel where you can pop your questions in. As I say, I will be having a look at those, starting off with the Brexit questions and then going on to the COVID questions. But please do ask those questions, because if you are thinking it, there is at least one other person in the room who has the same question. And it doesn't just have to be questions about today's webinar. It could be any questions that you may have or business concerns that you have. We also love to hear from you in relation to what you would like to hear as future webinars, so that we can help you and support you where you need. These webinars are only as good as the information that is provided, and it's only if it's suitable for you. So if there's anything you want us to cover, please do let us know. And before I get on, I look forward to answering your questions and being able to help you. And again, just a quick reminder that a recording of this webinar will become available early parts of next week. So if you do need to go, I won't be offended, and you will be able to go back and review it at your leisure, particularly if I go over time and you want to see if there is anything that I have that you've not managed to get, or if there's something you want to go over again. So as I mentioned earlier, I'm going to be splitting this webinar into two. First dealing with life after Brexit, and then I will be moving on to COVID and employment matters. Got lots that I want to cover today, so let's get on. So we all know from the 1st of January 2021, the UK left the EU, and new rules applied for businesses and citizens that took effect from this date. The UK has introduced a new points-based immigration system, which was launched, and that was the end of the free movement. So when we're having a look at what we're going to be covering, as I've already mentioned, we need to have a look at the big picture. And the big picture is that there are some key characteristics of the new system, which is of a particular importance for employers. And all employers should be aware that EU citizens who arrive in the UK on or before, well, would have been before the 31st of December, which is long gone, they have until the 30th of June to make an application under the EU settlement scheme. That is really important, and I'll cover that a little bit more detail later. EU and non-EU citizens wishing to come to live in the UK from the 1st of January will need to demonstrate that they have the right to be in the UK, just like non-EU citizens. So there is that difference between those who were here before the 31st of before the 1st of January and those who come in after the 1st of January. So the immigration skills charge will be levied on UK employers for all skilled workers. There will also be a sponsorship requirement that will apply to the skilled worker route for EU and non-EU citizens. The sponsorship process, whilst it has been streamlined and simplified for employers, this has been done to try and reduce the time that it's going to take to bring migrant workers into the UK. We do know that also the cap on Tier 2, which is the general visas, has been suspended, which means that there is no limit on the number of skilled workers that now can come into the UK. The resident labour market test has been abolished, but anyone coming into the UK for work will need to demonstrate that they meet and satisfy a set of requirements which those points will be allocated. And skilled workers will need to get at least 70 points or more. 50 of those points are non-tradable. In other words, they are mandatory requirements that are critical to allow them to be able to come in as a skilled worker. There are other changes that are being made, such as the introduction of a global talent route, changes to the innovator and startup routes, and the intra-company transfer and the intra-company graduate trainee routes are also being changed. A graduate route will be launched later in 2021, and this will allow international students the opportunity to stay in the UK to work, or allow them to look for work after they have graduated. So what does all of this mean for you and your employees? So at the same time the free movement ended, we had the EU settlement scheme, which was introduced, and we have that deadline that application needs to be made. So all applicants, so this is for employees, EU citizens who are already working for you, they must submit their application by the 30th of June 2021. It is to be noted that, of course, that if an EU national doesn't do this, what it will mean is that they would be left undocumented. And what this means is that they will lose their rights to healthcare, employment, rental property, and certain state benefits. There are no exceptions to the application requirements, and it doesn't matter how long the EU national has already lived in the UK, they must still apply for this. But from an employment point of view, the updated status will need, so I take all of that back. So Even though an EU national will need to make an application and their status will be updated, the legal responsibility is on the individual. It is not on the employer. And that sort of puts an employer on some very difficult sort of situations. So for example, if the border agency come knocking on your door and they want to find out whether you've done your right to work checks, where does that leave you with EU citizens who were working for you prior to the application date, the 30th of June 2021. So are employers allowed to ask questions? Are you allowed to ask whether your national that you know is an EU national, whether they have made that a settlement application? And the answer is no, you are not allowed to ask them whether they have made the application at all. You should not inquire whether the application has been made, and you should not ask them for any evidence whether the application has been made, or even what the status is. And the reason for this is because they can be linked directly to the person's nationality or their race, which of course is potentially deemed to be discriminatory in employment practices. So you need to be very careful in how you approach this by, on the one hand, making sure that your employees do make that application, at the same time satisfying any right to work checks as an employer. So there is no requirement for employers to carry out checks to confirm that that they have been granted pre-settled or the settled status under the EU scheme. But what you can do is you can ensure that your affected employees are aware of the requirements and they are aware of the deadline. And by this, you can make sure that any information is freely available to them. And we would ask, and we would certainly suggest to employers that you go about this in a proactive way by supporting employees with the application process and by publicising what those needs are, what needs to be done, and how they can go about the process. In terms of retrospective checks, so those are the retrospective checks in terms of the right to work. Provided you have already carried out those checks prior to the 1st of January 2021, you do not need to repeat the process again. So that is a sigh of relief to know that you don't need to go through that right to check work again. You also don't need to carry out checks on whether the employees have confirmed that they have been granted the pre-settlement or the settled status. So again, you don't need to do it again. Of course, if you've got any new employees joining you who are from the EU, you would go through your normal right to work checks at that point, and that will be irrelevant whether so would be regardless of whether they have been here for a short period of time or whether they've come over as a skilled worker. Of course, with all of these new requirements, it is going to put staffing recruitment pressures on organisations, because the EU nationals represent quite a sizable proportion of UK organisations who use the European talent pool to get their workers. What I would recommend to employers is that you create a talent pool impact assessment. And what I mean by this is looking at your workforce. Have a look at whether there are certain areas in your business that may draw on EU nationals. And it may be something that you have to put in certain measures, certain changes to be able to make sure that you can attract the right candidates for those particular roles. Identify areas in your business that will be most affected by Brexit. I know many of you have probably already done this, because here we are, 22nd of January, with 22 days into Brexit, and you've probably already looked at this. But many of you might already have put that on hold because, of course, we've got COVID and we are in a national lockdown. But Brexit will have an impact on your EU recruitment, and employers will need to ensure that they continue to have access to those skilled workers for their businesses. Again, as I say, what is really striking about the new immigration system is there is no route for the lower skilled workers, which of course many of us rely on in terms of fulfilling that talent pool. So it'll be very interesting to see whether the government has a change of heart on whether they make a change to this once they are once they have had this new once they've had this new immigration point system implemented, embedded in, whether they feel that there actually is a need to include something to address those lower skilled sectors of the economy. But of course, employers do still have low-wage worker options that they can do to still get these low-skilled workers into work. And that can be through foreign workers via non-work routes, such as those coming to the UK with their family. Alternatives can also be to use the temporary or short-term visa schemes to be able to fulfill those gaps. You can also use the Tier 5 scheme, which is currently available. And the Tier 5 really is about those on the volunteer sector, and I'll talk about that a little bit more. So, as I said, the new points-based system has already come into force, and as I mentioned earlier, the candidates who are applying for these visas will need to meet set specific requirements, which they will score points. As I said, they will need to get at least 50 points that are mandatory. When you're having a look at the application process, there's 3 criteria that the applicant must satisfy to achieve those 50 mandatory points. And that is in addition to passing the UK criminal checks. Under the new scheme, all applicants will need to be offered, and that this applies to both EU and non-EU applicants. They will need to have a job offer from a licensed sponsor. So licensed sponsor, quite important. I'll come back to that in a minute. Before they can actually apply for this, they must have the required skill set, and they must be able to demonstrate that they can actually speak English that have to an acceptable standard. So again, there are various ways that we will be able to have a look at that. So let's just turn to the licensed sponsor. In general, to be a licensed sponsor, the organisation must be able to demonstrate that they are a genuine business. They are solvent, and that the rules that they wish to recruit, the roles that they wish to recruit are credible roles, and they meet the salary requirements and the skill requirements, because those 2 things are requirements that the applicant must have. So it's pointless becoming a licensed sponsor if you're not going to have those skill requirements and you're not going to be able to pay the wages to satisfy those skills. To make sure that there is no slavery involved, so that you are complying with the various requirements, senior personnel and key users of the being a licensed sponsor will need to go under criminality and other security checks themselves. So, it is quite rigid tests that they do go through when they are going through the sponsor license application. Sponsors will also have to pay a fee, and there will also be an immigration skills charge. So not only is there a fee to become a licensed sponsor, for every immigration skill candidate that you take on, there will be a charge for that as well. So the existing Tier 2 sponsors, so those are with general or intra-company transfers who are already sponsors, you will automatically be granted a new skills worker or an intra-company transfer license. You won't need to reapply for it. It will be automatic. The level of the fees for the sponsor license will depend on the size of the company, and it will also depend on the route that you apply under. And this can range from £536 right the way up to £1,476. The immigration skill charge is £1,000 per skilled worker for the first 12 months, with an additional charge of £500 for each subsequent period of 6 months. Of course, discounts will apply to charities and SMEs. So let's have a look at the minimum level of skill. So this is the job must be rated with the minimum skills. And this is judged by the regulated qualifications framework of a level 3 or equivalent. In UK terms, this is at A level or an equivalent qualification. Workers don't actually have to hold a formal qualification, because it is the skill at the level of the job that they are actually going to be doing, which is the important thing. Knowledge of the English language. Skilled workers must be able to demonstrate this ability at a B1 of the Common European Framework of Reference for Languages. And again, in UK terminology, this is at AS level or equivalent. There are actually different ways where you'll be able to demonstrate proficiency, and that will include being a national of an English-speaking country, or having had an academic degree taught in English, or being able to pass the English language test. There are, of course, criminality thresholds which will also apply. So again, an applicant who is going to be going through that will go through some quite stringent criminality checks before that their application will be approved. And of course, the UK has got tougher criminality thresholds which go to their conduct as well, which is really important. The tradable points. So as I've already mentioned, your applicant must have 70 points to be able to apply. And these include having a written job offer that has been approved by a sponsor. The job must be at the appropriate skills. The candidate must speak English at the required level. There are also different requirements in terms of salary thresholds. So again, the different level of salary that is going to be provided will provide different levels of points, and the minimum salary entry point is £20,480. Of course, you will be able to, if the candidates can demonstrate that they are going to be doing a job that is in shortage, that of course will attract more points. If they have an education and qualification, so for example, if they have a PhD in a subject relevant to the job, that will attract additional points. And if they have a PhD in STEM, again, in a relevant job, that again will attract greater points. And it's really important that employers must keep up to date with these changes, particularly in light of the sponsorship scheme. So if you are going to be a sponsor, it's your responsibility to make sure that you're kept up to date in relation to the changes that may take place. As I say, it's still early days. We're only 22 days into it, so we will, we will keep you up to date. But of course, there are many places where you can. What employers must do, remember, is employers who do not hold a valid sponsorship license will be unable to hire migrant workers coming into the UK or extend visas for those current sponsored employees. So again, if it's something that you want to do or you currently have, you must have that valid sponsorship license. All sponsors have to be fully aware of immigration duties and have processes and systems in place both to meet those requirements and to maintain the records as evidence of your compliance. Employers without a sponsorship license are urged, of course, to act immediately to get that sponsorship license, and it's taking around about 8 weeks for those licenses to come through. So if you haven't done it and you need it, we would urge you to do it as quickly as possible. Of course, there is the immigration's health surcharge. As we know that all non-EU non-UK citizens will have to pay a surcharge of £400 per year. As an employer, you may want to pay that to support your workers coming in, but do bear in mind you're not under any legal obligation to do that. You're not required to do it, but of course, if you wanted to, you could. So let's have a look at some of the specific changes that Brexit is going to be having on employment law, because of course that's what it's all about. Over the past 40 years, the EU has influenced and on occasions radically changed UK employment law. Sometimes the link is quite obvious. There are some standalone regulations such as the working time regulations or the transfer of protection of employment regulations. These are two that jump to mind when we talk about EU employment law. But there are many other rights that are scattered throughout our employment legislation, and these have their origins from the EU directives. Examples will include health and safety rights, which are in the Employment Rights Act. These have become quite prevalent, particularly in light of COVID, and that is to protect workers who leave their workplace where they feel that they are in circumstances of danger that they reasonably consider to be serious and imminent. We've seen that quite a lot with employees wanting to refuse to come into work because they are in fear of their lives because of COVID-19. Other employment law provisions are more complicated with the relationship in EU. So, for example, a right to the written statement of terms and conditions, which we all know changed as part of the UK updates in April 2020. The rights first applied back in the Contracts Employment Rights Act of 1963, but it was amended in 1991 to comply with the Proof of Employment Relation Directive, which came out of the EU. Of course, much of the Equality Act 2010 is underpinned by EU law, and a lot of the key aspects of that goes beyond what is required in UK law. And of course, the directives all relate to discrimination. And the relationship between EU and domestic employment law is messy and complicated. But luckily, with the terms, with the exit agreement, we do not need to untangle this. Because as of the 21st of January 2021, nothing has changed, because the EU law, as far as employment law was concerned, has been retained, and all laws derived from the EU will continue to apply until Parliament steps in and makes amendments. And of course, we know that that is going to take time. When courts are interpreting those laws, they will continue to do so with the principles of EU law, and the supremacy of EU law must continue to be respected, even, particularly in light of those rules that are already in force as of the 1st of January 2021. But there are a couple that are sort of on the horizon where we are having a look at. So, for example, when considering the calculation of holiday pay, employment tribunals will continue to disregard the limited definition of a week's pay provided in the working time regulations, and will apply the EU definition of what normal remuneration is, which includes things such as overtime and commission. We do know that there is a Supreme Court case which is due to be heard in the summer. This is an appeal in relation to whether holiday calculation should include voluntary overtime. So that will probably be the first time where the UK courts put their stamp on what will apply in terms of voluntary overtime. So watch this space, and we'll wait and see what comes out of that. The question for the future is not whether the courts will interpret the law differently, but whether existing law will be amended by Parliament. Of course, we know as yet the government has given no indication on what aspects they want to change. Of course, there are a list of outstanding commitments in relation to employment law. There are still measures outstanding which were proposed in the Taylor Review, which were consulted on and never followed up. There are also proposals from the Conservative Party manifesto from 2019 relating to redundancy provisions and which provide protection for new parents and additional leave for carers, which still will need to be enacted at some point in the future. But we fully anticipate that the government will publish its employment bill probably a little bit later in this year. But I would be surprised if there weren't at least some of the additional reforms put forward that simply could not be done before the 1st of January. So again, it's about a case of let's watch this space. The Court of Justice European Union, whether the tribunals should be taking this into account. As we know, from the 1st of January, the Court of Justice of the European Union has no jurisdiction over the UK domestic courts and tribunals. And what this means is that the tribunals will only be bound by rulings made by the Employment Appeal Tribunal or the Court of Appeal or the Supreme Court. So let's just have another quick look at what is the impact of Brexit on your payroll. So again, this is something that may sort of slip under the radar, but from the 1st of January, an employee will only pay social security in one country, and it would normally be the UK if that is where they are working. Coming to work from Ireland as a UK or an Irish national or other national who is lawfully resident there will continue to pay social security contributions in Ireland. In certain circumstances, social security payments will be paid in the country, in the originating country, in which case the employee will have to provide a certificate to show that social security contributions will need to be paid either in the UK or elsewhere. It is for the employees to apply for the certificate or the documentation for the document in the country where they wish to continue to pay those social security contributions. If the originating country has adopted the detached worker rules, contributions can continue to be paid in that country for up to a period of 2 years. So an employee coming to work permanently in the UK from the EU, Norway, Iceland, Liechtenstein or Switzerland will should begin to pay national insurance contributions to the UK from the date of their arrival. So from an employer's point of view, you must check if your EU country that the employee is being moved to has agreed to apply to that detached worker rules. And if that is going to be the case, you need to do that by the 1st of February 2021. Of course, an employee is eligible to carry on paying UK national insurance. They can continue to receive free healthcare cover. So the two are linked. So another question that has come in about Brexit and employment is, what about volunteers? Can EU workers carry on volunteering in the UK? And the simple answer is yes, if they have a settled or pre-settled status and they have a visa which doesn't prevent them from volunteering. So if a volunteer doesn't have a visa, they may not be able to stay in the UK. An organisation should be aware that under the Immigrations Act 2016, it is a criminal offence to involve these workers as volunteer workers, as a type of volunteering where the contractual of mutual obligation, so that is, the promise of work and work to be carried out, but no pay. If there is a possibility that the volunteer could be deemed to be working under a contract, even if they have no pay, then you should check whether those volunteers have the right to work in the UK. The rules on people working from overseas, volunteering in the UK, are complex and sometimes contradictory. So I would strongly advise that if you are going to be using volunteers, that you have a look at this. And one place where you can really sort of watch this is the Tier 5 visa application, and this is the temporary worker unpaid charity worker visa. This can be used specifically in the context of volunteering. We do anticipate that there will be changes, and you know, as I say, we are only 22 days into Brexit and employment matters. So I'm just going to have, I'm going to take a pause here. I'm doing really well for time. I think in terms of the split, you know, I've sneaked into about 5 minutes. But let's just have a quick question. Let's have a quick look at some of those questions in terms of Brexit and HR. And so, of course, if anybody is specifically on this webinar to deal with that specifically, they can then be free to go. So Vipin, your question relates to sick leave since the beginning of December. I'm going to park your question because that's going to fall in the second part of my question, and I think I'm going to be able to answer you. So I'm listening from Tenerife, and I'm the furthest away from England. Congratulations, Jeremy. I'm not too sure what the question is, but it's fantastic to hear that we are reaching people as far and wide as what we are. Thank you for joining us, and I hope you find that this is you know, useful and helpful. So my next question comes from Bhavana or Bhavna. Apologies if I've said your name incorrectly. Your question is, are these changes and requirements for EU workers only due to Brexit, and outside EU worldwide employees carry on with existing laws? Are they very different? So just to answer that, so there's two aspects to your question. From the 1st of January, all EU citizens coming into the UK will be treated exactly the same way as worldwide applicants coming into the UK, and that will be on that points-based system. Those employees who are EU citizens who are already here, all they need to do is to apply for that settlement status. It shows that they can get that settlement status, so that they can stay and continue to working in here. They are different. One is, you know, for those who are already here, they don't need to go through that application process again because they are already here. But anybody joining, wanting to come over to the UK, well, already, because we've already passed the 1st of January, they will need to go through the system in exactly the same way as anybody else from a non-EU country. So I hope that answers your question. If not, you know, certainly do come back to me. So that looks like, Abby Reid, it may well be that you've had part of another question because you are just clarifying, and I can't really see it at the moment. So let me see if I can just squeeze my box out a bit. Let's have a look if I can do that. Bear with me one moment. Oops, now I think I've lost you. Bear with me one moment. Technology has failed me today, everybody, so I do apologise. And now my laptop is trying to link me into Zoom, so I'm not sure what has happened there. I have to apologise. I've lost the questions, but what I will do is I'm going to try and get them back up and see how I can do that. Oh, there we go. Let's try that. There we go. I'm back. Apologies. Clicking the wrong button here. Abby, so to clarify, the onus is on the employees who were employed prior to Brexit implementation to apply for the settlement status. Yes, that is correct. It is not the employer's responsibility, it is the employee's responsibility. They need to make that application. But what you as an employer can do is help and support them in providing them with, knowing, advising them that there is that deadline if you are aware of them. Of course, don't pick them out individually because they may feel that they're being picked on, but by giving out a company-wide communication, addressing all workers, and saying those of you who need to apply for the settlement status, don't forget you've got that deadline of the deadline in June of 2021, and of course, offering, if you need help and support, come and speak to us. Let us see how we can help them. So you're absolutely right. The obligation is on the employer, not on the employee, not on the employer. The next part of your question is, does that mean that the employer is not liable if they do not? And again, I'm going to try and get to this question. I'll just move that. What is that going to do? It's not going to help me. So does that mean the employer is not liable? So I can't see the rest of your question, but I think what you're trying to say that is if an employee does not get that status and you have the border agency knocking on your door to do those right to work checks, and it turns out that that individual is undocumented, you as an employer will not be penalised for that because you would have been able to demonstrate that you had carried out your right to work checks prior to the 1st of January. Of course, if you've got somebody new coming in, the new rules will apply and you will need to carry out those rights to check checks in any event. So I hope that answers your question. But I will. The beauty about these webinars is that we do collate all these questions. We do formulate a Q&A document that we do send out on it. So Abby, if I haven't answered all those questions, or if anybody is sort of sitting on the edge of their seat waiting for me to answer the rest of the question, it will come out to you and I will make sure that the answers are, answered more fully then. So let's just have a quick look to see if we've got any other Brexit questions. I have answered that. You're welcome. No other questions from Abby. That's great. As I say, I will sort of get those questions and I will collate them for you. So let's have a look at the second part of the today's webinar, and that's having a look at COVID and employment law. And how this has been growing. We are all well versed at this now. We've been at it for, can you believe it? 10 months. The last 10 months we have been grappling with COVID, how to deal with it, how to manage it. So I think by now we are all well versed with the coronavirus, the job retention scheme, whether it is on a full-time furlough, whether it's flexi furlough. We're starting to get used to these lockdowns. We are now in national lockdown version 3, but I thought it would be really useful at this point just to touch on some of these issues that are questions that are constantly coming into HR for UK. And of course, lots of people have lots of questions around vaccinations and what we can and can't do in relation to our employees, and I am going to cover that quite a bit. But just let's have a quick look at other matters that have had an impact on your business in relation to COVID. So of course, as an employer, you have a legal duty to protect your workers from harm. You should make sure that you consider the risks to workers, and particularly those who are more vulnerable to COVID-19, and you must make sure that you put measures in control. Now, when I'm talking about those who are more vulnerable, I'm talking about those who are considered to be clinically extremely vulnerable. So those are individuals who have been issued with a letter to shield. I mean, if you remember back in March of last year, this was all very new to us. We got these letters of shielding. We then, people who were shielding were encouraged to get back out into society, and shielding was no longer provided. In lockdown version 2, the government didn't, enforce shielding, but of course in lockdown 3, they have once again, given out clear guidance in terms of those who are shielding. And and that is because they are at a greater risk of becoming incredibly ill with COVID-19. So those people who are shielding, and I'm going to jump onto that because I was actually going to talk about something else, but whilst I'm talking about shielding, I might as well carry on with it. So I'm just going to jump to my notes on shielding. So shielding is where people have received an actual letter informing them that these employees should work from home if possible. In fact, they must work from home if possible. But if they cannot work from home, they really should not attend work. Now, I know that we've had quite a few organisations coming in challenging that, but as a responsible employer, I would urge you to really think about those people who have been medically advised to stay at home, and they should not go to work. We have had situations where there are employees who are quite willing to come into work and then have a change of heart, which the employer then feels, well, you said yes and now you're saying no, you know, where does that leave me? Our advice to you would be to follow the guidance and to make sure that those employees should not attend work. If their role is absolutely business critical, the business cannot continue to operate without that individual in the workplace, then of course you need to have a look at the balancing act of getting that individual into work. And if you do have, excuse me, clinically extremely vulnerable, I've got a frog in my throat, so I apologise. If you have to get them to come into work, you need to make sure that the workplace is COVID secure and that you carry out a risk assessment for that individual and put in additional measures to make sure that you can give them as much protection as you possibly can. People who are clinically extremely vulnerable, who were on your payroll before the 30th of October 2020, who cannot attend work, may be eligible for the coronavirus job retention furlough scheme, which of course we know has been extended until the 31st of April. And they may also be eligible for statutory sick pay, or if they don't qualify for that, they may be eligible for employment support allowance or universal credit measures which are in place. There is also, of course, you know, the ability to be able to make the application for the one-off payment of £500 under the test and trace scheme. So all of that may be used in terms of getting funding for your employee. But if it is absolutely necessary for your employee who is clinically extremely vulnerable to attend work, because there is absolutely no alternative, you must make sure that that workplace is secure. We do know that you have the furlough scheme that you can put them on. The coronavirus job retention scheme is the preferred way to be able to fund them, to make sure that they are not disadvantaged because they are extremely clinically vulnerable. So just having a look at pregnant workers. So we've had quite a few questions about pregnant workers. Now, before the guidance was a little bit vague on that, but the most recent guidance that has been issued, there is now a clear distinction between those who are less than 28 weeks pregnant and for those who are more than 28 weeks pregnant. So let's just have a look at pregnant workers. Pregnant workers have been advised, of course, to follow strict social distancing and to reduce the risk of severe illness as a result of coronavirus. We know already, established in employment law, that there is a long-standing requirement for employers to put measures in place to ensure the workplace is safe where there is a significant health risk for new or expectant mothers. That is not something new, that is something that has always been in the employment law. But some pregnant workers will be at greater risk, and in some situations they will be defined as clinically extremely vulnerable, and they should stay at home as much as possible and work from home if they can. So recommendations apply for women who are less than 28 weeks pregnant with no underlying health conditions. Pregnant workers, of course, you must have a risk assessment in place. The pregnant employees should only continue to work if the risk assessment in place advises them that it is safe for them to do so. This means that from an employer, you should manage the risks. You should have a look at those risks, see if you need to put in additional measures. And of course, if this can't be done, you should consider offering suitable alternative work, including working arrangements. And of course, that is working from home. You can suspend your employee on full pay. And of course, you can use the coronavirus job retention scheme to be able to put them on the furlough scheme, reducing that pay to 80% of wages. And of course, you must ensure that you are able to comply with the social distancing measures and also national guidance on any other measures that are in place. Of course, we all know it's hands, face and space. Recommendations that are now applied to pregnant women who are 28 weeks or beyond, or for those who have underlying health conditions. Of course, they are at a greater risk of severe illness from coronavirus. And the recommendations is an employee who is 28 weeks pregnant and beyond, or if they are pregnant and have underlying health conditions that puts them at greater risks, you should take a precautionary approach. And although the employee is no more at risk of contracting coronavirus than a non-pregnant employee, the risks that they face is the increased risk of becoming severely ill and of preterm birth if they do contract the virus. And of course, again, we would strongly urge that they will then fall under the critically extremely vulnerable employee. And we know that the guidance there is that they should not come into work. They should stay at home and, if at all possible, be able to work from home if they can, and if they can't, look at alternatives. And of course, the alternative is putting them on the coronavirus job retention scheme, sorry, not retention scheme, support scheme. So, you know, it is really important that we do take these, you know, risks seriously, and we do put those measures in place. Sick pay is another one which continuously comes in with questions. You know, we have your ordinary sick pay and leave, and that is where people are sick for reasons other than COVID-19, and those rules are the normal rules that will apply where you need to have the, you know, the 3 days waiting period, and only on the 4th day does the sick pay scheme kick in. But of course, if an employee cannot work because of COVID-19, they could get statutory sick pay if they are self-isolating because they live with someone or they are living with someone who they themselves are self-isolating because they have coronavirus, or they live with someone who is self-isolating because they have coronavirus symptoms, or they have tested positive. So sick pay could apply there. Sick pay could apply if you've been notified by the NHS or the public health authorities that you've been in contact with someone with coronavirus. You could also pay statutory sick pay if someone in your employee support bubble or extended household, if you live in Scotland and Wales, has coronavirus symptoms or has tested positive. Or an employee has been advised by their doctor or health professional that they should self-isolate before going into hospital for perhaps surgery. They could be given statutory sick pay. But I would always advise employers to take a considered view whether statutory sick pay is more appropriate, or whether it would be more appropriate to put them on the coronavirus job support scheme, the furlough scheme, because of course the difference is the level of pay, and would you really want to put your employees at a disadvantage by putting them on statutory sick pay when there is the option and the alternative of putting them on the furlough scheme under the job I keep referring it to the retention scheme. It's the job support scheme, the coronavirus support scheme, the extended scheme. So statutory sick pay could also apply if you work in an area with restrictions. Well, we're all in a national lockdown at the moment, and the advice is to put your employees, if you have to close, into the coronavirus support scheme. So again, reminding myself of the right scheme there. So just turning to the point of vaccinations. Vaccinations have become a hot topic. We know as the COVID-19 vaccination gets rolled out, certainly as we're starting with the more vulnerable groups across the country, employers might start be thinking about reintroducing their staff back into the workplace, particularly those who have perhaps been off work for almost a year under the furlough scheme, or home working, or getting under tough conditions. Employers might, the questions that are springing up is, can I make it mandatory for my employees to get the COVID jab? And the short answer is no. You cannot force staff to get immunised against COVID-19. Getting that COVID-19 jab has to be a personal choice, and you as an employer cannot force it on your employee. So what you can do though is that you can strongly recommend your staff that they have the vaccine. It is reasonable enough to make sure that they are aware of the benefits of getting the vaccination. But of course, employers, you must be aware that there may be health reasons, religious reasons, or other reasons that employees may not want to share with you, whether they want to or don't want to have the vaccination. Some of them may have trust issues, some of them may have hesitations due to the rapid development of the vaccine, but you do need to take that into consideration if an employee is reluctant or refuses to have the vaccination. Terminating employment because of that refusal would be considered as discriminatory, and they would be well within their rights to resign immediately. Terminating their employment would be give rise to an unfair dismissal. Again, if you are going to be pushing the issue, an employee may resign and claim constructive unfair dismissal. So making it, forcing it or making it mandatory does have very complex employment matters. So certainly do not force the issue, but of course what you can do is encourage staff, but don't make it mandatory, and don't isolate individuals out for choosing not to do so. So questions again that have cropped up is, do my employees need to tell me that they are going to be getting the vaccination? No, they don't. Again, bearing in mind that this type of information is data which has special protections under the GDPR, under data protection. So your employee does not have to notify you that they are getting the vaccine. You are not, you should not be asking your employees if they are going to be getting the vaccine as well. Again, questions that have come in asking whether I can alter contracts so that my staff have to get the jab, or add an immunisation clause into their contracts. Whilst in principle you can, but it's not easy to do. because of course you will need to get the approval from staff in order to make those changes, because it would be a variation of term. But I think it's going to be incredibly challenging, particularly if you already have employees who either don't want the vaccine or see it as unethical to make it mandatory. Again, it is really important that you consider your reputation if you are going to force that change through. And again, you will need to be mindful of forcing a change through like that could give rise to a constructive unfair dismissal claim. And I do believe that in these sort of situations, it would be very hard to be able to justify why you have forced it. Of course, it might depend on the industry that you are in. So healthcare workers, it would perhaps be a little bit more appropriate. Nursery schools might be a little bit more appropriate than your run-of-your-mill, perhaps office-based or factory-based organisations. So again, it will be on a case-by-case basis, but I would urge you to be very cautious and of course follow due process if you are going to implement those changes. But again, you wouldn't be able to implement those changes without the express consent of employees. What about interviewing candidates? Can you ask them, so this is at interview stage, can you ask them whether they've been vaccinated? And the answer there is no, because you can't ask potential employees whether they've been vaccinated unless there is a compelling health and safety reason to ask why. Again, this is seen as sensitive data, so in most cases it would be deemed to be inappropriate to be asking at interview whether they have had that vaccination. It's a bit like asking an employee whether they intend to have children. It's one of those taboo questions you do not ask, because of course there is the general prohibition on employers asking prospective employees health-related questions, and in this case it would include vaccination records. So another question that has come in: how can I encourage staff to get the COVID-19 jab? As I've said before, you can't force staff to get the injection, but what you can do is certainly encourage them to do this. And this could be by providing reliable information or supporting staff in getting their vaccine in other ways. We would certainly encourage our clients to encourage their employees to get vaccinated. Make sure that I say they have access to reliable information about the vaccine, so that your employees can make an informed choice. Something that you may want to consider is allowing paid time off for vaccination appointments. We have no guidance on how it is going to be rolled out to the rest of the individuals in the UK, but you might want to have a look at allowing time off, paid time off to go for those appointments. Of course, there is no legal obligation for paid time off for medical appointments, because this would be considered as a medical appointment, but it might be something that you would want to use to encourage staff to have that vaccination. So look, you're not going to it's not going to be treated as unpaid. You'll get paid, but you may want to also consider when we get to that point to try and encourage staff to if they are going to have vaccination, perhaps if at all possible, have those vaccinations outside of normal working hours. We've all seen talks of it being 24/7. I'm not too sure I'd want to be going to have a vaccination at midnight, but it may well be appropriate. But again, if it's going to be during work time, you may want to consider that it is paid time off for the vaccination. But of course, you are not obliged to do that. So again, quite a lot to cover there. Just a very quick reminder, I'm just sort of looking at the time, we've got quite a lot of questions. We've gone past 4 o'clock, but I just want to go through a quick reminder on the full range of business support measures that have been made available to UK businesses by the government. So of course we know that paying your employees, this is a UK-wide support scheme. There is the coronavirus job retention scheme. Of course, there are the eligibility criteria that applies to that. There is also the Kickstart scheme, so you can claim the grant for the Kickstart. I know many of my clients and non-clients who are perhaps listening to this are thinking, I've made my application for the Kickstart, but we've not heard anything. Our hands are still tied behind our backs in relation to further information from the DWP as to where we are. We know that we have gone, HR for UK is an authorised gateway, so we have gone through those fiscal financial checks. We know that our first application has gone through, that those financial fiscal checks have been carried out. Some organisations have been flagged up, but we are still waiting for more information. So if you have made an application, please do bear with us. We are fighting your corner to get those Kickstart grants as soon as possible. I've already talked about paying sick pay. So again, check if you can claim back statutory sick pay paid to employees due to COVID. Paying tax, so of course we know that this is again a UK-wide support measure that's been put in place. So of course there was the paying VAT on a deferred basis due to coronavirus. There are, of course, the business rates relief. This is, of course, to England only. You will have different guidance for Northern Ireland, Scotland, and Wales. But, of course, business rates relief in England. Check to see if your retail, hospitality or leisure business is eligible for business rates relief due to COVID-19. And again, for those of you who run nurseries, check to see if you have, if you are eligible, your nursery is eligible for business rates relief due to COVID-19. For small and medium-sized businesses, again, UK-wide, you can apply for the Coronavirus Business Interruption Loan Scheme. You can apply for the Coronavirus Future Fund. You can apply for the Coronavirus Bounce Back Loan. So there is financial help there. For larger organisations, you can, this is again UK-wide, you can apply for the Coronavirus Large Business Interruption Loan Scheme. You can apply for the COVID-19 Corporate Financing Facility. And of course, you know, something that really resonated with me earlier in the week, where there was the test case in terms of lots of businesses who had a cover in place, and there has now been the decision. I don't have the details with me, it's just come to my mind and I thought I would mention it, is of course check your insurance policies, because you may be able to make a claim against your insurance policy, because of course that test case has come through that insurers will have to pay out in terms of organisations who have had cover in place for closures to business. So again, you know, another way, check your policies, check to see if you have that insurance cover. And I know my insurance colleagues will not be thanking me for that, because I will be, of course, encouraging more work. But from a business point of view, do check your insurance policies to see if you have that cover, because that test case has been covered. So again, looking at businesses affected by coronavirus restrictions, and these measures that are in place are for England only. I would recommend that for Northern Ireland, Scotland and Wales, you look at local guidance, but check to see if your business is eligible for the coronavirus grant due to national restrictions. This is for closed businesses. Check if your business is eligible for the coronavirus closed business lockdown payment. Check to see if you're eligible for the coronavirus additional restrictions grant. Check to see if your nightclub, dance hall or adult entertainment business is eligible for the coronavirus grant due to the national restrictions. Again, check to see if you are eligible for the coronavirus local restrictions support grant. This is for open businesses. Check to see if you are eligible for coronavirus local restrictions support grant for closed businesses. And the last one, check to see if you are eligible for the Christmas support payment for wet-led pubs. So lots of support there. Make sure that you take advantage all the support that is available to you. So I've managed to hold on to quite a few of my audience, so well done to you. Let's have a look at these questions that have come in. So Vipin, you were very patient. You were our first question that came in. You did ask the question earlier, and your question is, how do you deal with staff on sick leave since the beginning of December 2020? Now, the question to you is, and I will answer both, is it will depend on the reason for their sick leave. If they are off on sick leave because of COVID-19, you will be able to, subject to the eligibility criteria, you will be able to pay them statutory sick pay, and you will be able to claim back that statutory sick pay through the government. If it is in relation to anything else other than COVID-19, so for example, perhaps they are off sick because they are undergoing treatment, perhaps they've got cancer treatment, that will be treated as ordinary sick pay. It will be ordinary sick leave, and that will be under the normal rules. So the first 3 days would be unpaid, and thereafter for a period of up to 26 weeks will be paid at the statutory sick pay weekly wage. Again, I will make sure that the difference is in the questions and answers with a more in-depth response for you. So Akara has got a question here. Is there any indication that the furlough scheme qualifying criteria will change? Is being employed prior to 31st of October 2020? Certainly there is no indication that the criteria is going to change. Of course, we know that the scheme is only extended until the end of April, but of course we know the government, we have flip-flopped around this criteria a number of times before. I should imagine, and this is without any authority, that if the scheme is going to be extended beyond the end of April, they may well have a look at that eligibility criteria. But at the moment, to be able to go onto the jobs support scheme, the furlough scheme, it will be as at the 31st of October 2020. So I hope that answers your question. Question from Joanne in relation to if a 28-week pregnant worker, not an employee, has no underlying conditions and is insistent that they want to continue working, should we refuse to place them on furlough? So a couple of questions there. The pregnant worker who is not an employee, you cannot use a furlough scheme for somebody who is not an employee. So they would fall outside of the furlough scheme in any event. So you legally wouldn't be able to put them onto the furlough scheme because they are not an employee. So again, you look at the guidance, and I will provide you with a more detailed question on that. So from a legal point of view, you will have the standing to be able to say that they are not going to go on furlough in any event. They've got no underlying medical conditions. If they can work from home because you've got them as a worker, so maybe they're a contractor, maybe they're an agency worker, not quite sure of their actual status. If they can work from home, of course, try and do that. If it's not a job that can be done at home, make sure that the workplace is COVID secure. Make sure you carry out that COVID-19 risk assessment on an individual basis, and carry on working. Of course, if they want to start, if they don't want to be working, depending on what the terms of their working arrangement with you may dictate that they start their maternity leave sooner rather than later. But again, Jan, if you want to get in contact with us for specific detail on that, by all means, do speak to one of our advisors. So moving on to Carly, a lovely question here. Do employers need to allow reasonable time off for vaccinations? Brilliant question. We haven't had any specific guidance as to how it's going to be rolled out. But as a reasonable employer, we would treat getting vaccinations done in exactly the same way we would treat any other medical appointment. So allowing reasonable time off, you would perhaps, if we've got the choice of when we can make those appointments, in the first instance, we would request employees to try and do it outside of the working day. If it's not possible to do that, and if it is possible to book your own appointments, try and encourage staff to do it first thing in the morning or last thing at the end of their shifts, or perhaps during a lunch break, to try and manage the disruption to the business. But I would certainly, once this becomes, where we have lots of employees of, from managing your business, that you look at that. Of course, we don't know how close individuals are to the vaccination centres. I know vaccination centres are popping up all over the place, but it may well be that it's going to be quite a considerable period of distance for the individual to travel to be able to get that vaccination. So again, you might want to sort of consider it on a case-by-case basis. But again, if you're going to roll out something to all staff, make sure that you apply that fairly and reasonably. At the moment, it is not obligatory for you to allow reasonable time off, but as a reasonable employer, you would want to consider that. So I hope that answers your question. I know it was a bit in a roundabout way, but I hope I got there in the end. Rachel, your question here, the recommendation for expectant mothers over 28 weeks, if they are unable to do their job from home, you place them on the furlough scheme, how would this affect their maternity leave? And again, I'm going to run out of space to be able to see the rest of your question. Bear with me one sec again while I try and see if I can extend this. So again, I can't get the rest of that question, which is really frustrating. And I promise I will sort this out for next time. So what impact will it have on their maternity leave? So what will happen is that they will stay on furlough until they start their maternity leave. I will send out specific answers to this question because, again, I can't see the rest of your question. All I can get is, would it automatically be, and I think the question is that it's automatically going to start. So I would suggest, and again it would be on an individual basis, is that they continue within their furlough until they would have normally commenced their maternity leave, which is 2 weeks before their expected a week of childbirth. So again, it won't impact that. Of course, if the employee wants to start their maternity leave before that, they will of course need to notify you that they are bringing the maternity leave forward, in which case they would then trigger into their maternity pay in the normal sense, and of course that will apply in the normal maternity pay way. And I'm just being given your question here. So what would happen if the triggered 4 week prior to what would happen triggered 4 weekly prior to due date? Okay, I still don't understand the question. Rachel, what I will do is I will actually take this question offline, and I will get in contact with you specifically to answer this. So I do apologize, and as I say, I promise to get this sorted out before the next webinar. Next question from Bavna, thank you very much. Am I right, there is no extra help for closing the business being shielded and only one person working? I'm unclear whether that question is about the company support that you would get, so as an organisation, or the business support schemes that I've mentioned, or whether it is an individual. If you as an individual are a sole the only person working in the business, and you have been advised that you need to shield, there are no other means, depending on how your organisation is set up, There are, of course, if you're a sole trader, you know, there are different rules that will apply to whether you are a company, a limited company. So again, I'm not quite sure what your particular circumstances are, but again, I will try and make sure that in the Q&A answer sheet that goes out, I will separate it out so you'll be able to get the exact answer for both questions. Again, another question: what if you have to close for 14 days to staff being positive in monetary help? Okay, so if staff have tested positive, they have to stay at home. They have to self-isolate. There are two options. You can either put them onto statutory sick pay, and you can claim that from through the statutory sick pay scheme, or you could put them onto the coronavirus job support scheme. The choice is yours. And there is lots of sort of debate as to which one do you want to put them on. The one obviously pays 80% of wages, whereas statutory sick pay is a limited amount of a weekly wage. So again, have a look at both and put them onto the most appropriate scheme that is available. So the monetary help available to your employee is putting them on that scheme. The monetary support from the business, of course, is as long as they are eligible, you will be able to claim that back either through the job the job support scheme, or through the statutory sick pay scheme. You will be able to claim that back from you. Joanne, you've come back with more questions. Is your employee who is 28 weeks is on a 0-hour worker on a production line? Okay, so just casting my mind back to the previous question, she's 28 weeks, she's on a 0-hour contract, she's on the production line, so of course she can't work from home. You know, the question is, I can't recall, so I'll answer both. She has requested to go onto the coronavirus to be furloughed. The option is yours. The decision to put an employee onto the furlough scheme rests with the employer. So you can decide whether to put her onto the furlough scheme as long as she was on your payroll on the 31st of October 2020, then she can be furloughed. If you do not want to furlough her, you are not under any legal obligation to do that. If it is your decision, as I've already said, you've made that decision, of course, you can then put her onto furlough, but make sure that you give her that flexi furlough agreement, whereby she is agreeing to go on the furlough scheme. She is agreeing to only receiving 80% of her wages. So Jana, I hope that answers your question. And the last question that I'm going to be going into, because I'm really turning into a pumpkin, is isolation but negative test. So the question, I'm not quite sure what the question is. I'm assuming that an employee is isolating because they have got a negative test. If an employee has got a negative test, there is no reason why they should continue being in self-isolation. So without further information or further details on that, I can't give you much more of an answer of that. But if they are going to continue isolating because they've got a negative test, that's clearly a personal choice. From an employer's point of view, how do you deal with that? You can treat it as unpaid, because it certainly doesn't fall into any of the other categories. You know, they are choosing to self-isolate. There is no reason why they should be. So I hope that answers your questions. Thank you very much. Last question, isolation track and trace. Isolation track and trace asked that they have developed symptoms. I'm not quite sure what the question is. I'm going to take that offline. I'll have a look at that. And again, as I've said, have a look at the question and answer paper that will come out to you. We'll have more detailed answers for you, and hopefully you'll be able to answer. But always, you know, we are here to answer those questions. do get in contact with us. Our telephone number is 01455 444 222, and one of our advisors will be able to help you. Of course, we've got the, you can ask your question online by going to www.hrforuk.com and fill out a form from our website. And or you can drop an email in to our info inbox, which is info@hrforuk.com. But please do ask us. We are here to help you. If something is a little bit more complicated, needs additional help and support, we can provide you with the help and support. We are here for you. We want to help you. As I said right at the very beginning, this coronavirus crisis, I want to get you and your organization through this by providing you with that clear, practical support and guidance. So our next webinar will be on Friday, the 26th of February at 3 o'clock. What I'm going to be covering on the 26th is 2021 employment law changes that are on the horizon, and again I will give a furlough update. So again, employment law changes that are on the horizon. But don't forget about our HR surgery, which happens on a Wednesday. Our next HR surgery is at 11 o'clock on the 10th of February. It is pure questions. It is an interactive questions and answers. So again, if you want to, you can join us for our HR surgery. HR for UK are here and ready to support you, so contact us today. Again, a quick reminder, telephone number 01455 444 222, our website www.hrforuk.com, and if you want to drop us an email, it's info@hrforuk.com. We are always here to help you, and thank you very much for staying on right to the bitter end. Have an amazing weekend, everybody, and I'll see you back here at our next webinar. Take care and goodbye for now.